My name is Cynthia Mason. I'm a Canadian lawyer and trademark agent with the law firm of Mason PC and with our online trademarking platform, Markably. If you are a small business owner and you have encountered an online infringement of your name and you're thinking about taking some DIY steps to make it stop, I've created this video specifically for you. First of all, I just want to say we are all about empowering brand owners to take a lead role in policing their trademark rights. It's the main reason why we created this YouTube channel, was so that we could share information and make it simple for brand owners to protect themselves and their most valuable assets, which is basically their name, their logo, their tagline, or their brand. And so I want to share one single step that you can take as a brand owner before you take any enforcement steps online that will really set you up for success in that enforcement action. When you see somebody infringing your name online in an online platform, for example, Facebook, Instagram, Amazon, Etsy, the App Store, any platform really where you can sell products or services, chances are they have created an IP infringement complaint procedure where you can have the platform take infringing names down on your behalf. The procedures are very simple. They're set up so that brand owners can do it on their own and they don't have to hire a lawyer to help them. And so you should be looking at these procedures as a simple and inexpensive way that you can protect your name online. But I do want to caution you that before you take any steps in terms of filing an IP infringement complaint procedure against a third party, the one single thing that you should do that will protect your position and will help to ensure that you are not in a defensive position going forward in any trademark dispute is to take the steps to ensure you either have a trademark registration for the name that you're wanting to enforce, or you have filed a trademark application to get the registration process started. The reason why this is so important before you take any enforcement action is because here in Canada, and as well as in the United States, while the law says that the first person or company to use a name is the one who is entitled to register it as a trademark, which really means the one who is entitled to own it as a trademark nationally, is the first person to use that trademark in commerce. So the first person or company to sell something under that name. Now, when you file a trademark application, or when anybody files a trademark application with either the Canadian Trademarks Office or the United States Patent and Trademark Office, those offices don't investigate whether the first person to file the application was actually the one who started using it first. They just assume whoever filed the application first is the one who is entitled to register it as a trademark. And so they will examine that application and let it go through to registration unless the person or company who actually was the first person to use, so the person has earlier rights than the one who filed the trademark application, unless that person takes the steps to oppose. Filing the trademark application first puts you in the driver's seat when it comes to claiming ownership of a particular name, logo, tagline, or any other trademark. You want to be the one who has the first application on file to protect your position as the first to use and the first to be able to own it. So the minute that you file a complaint against somebody else, you're challenging them as a correct user, and you don't want them to take the steps to file a trademark application before you to protect themselves in a dispute with you. You want to make sure that you've got your application on file first so that you are in that driver's seat and not in the defensive position of having to oppose them. Because I can tell you, if you think that the cost of a trademark application is prohibitive for your business at the start stage, it is pennies compared to what an opposition procedure is going to cost you. In an opposition, you have to file evidence, you have to file arguments, you can attend an oral hearing, and it's years of risk in relation to your ownership of that trademark. All you need to do is take the steps to file your trademark application before you take any enforcement action, protect your position as the rightful one to use and to register a trademark, the rightful one to own it, and then take your enforcement actions to stop whoever is really infringing your trademark rights. If you want a fast, easy, and affordable way to get a trademark application on file here in Canada, visit us at markably.ca. We have a super easy to use platform, and it is built specifically for startup entrepreneurs to just get their trademark application on file, to get started with a properly filed trademark application that's going to go through to registration without any serious objections.